na at hindi kailangan ideklara sa SALN. Yun po ba ang teoryang sinusulong ninyo?
That depends, Your Honor. If what is involved is general delivery, then the law on delivery will apply. But in cases of specific instances, then the very contract between the parties, together with the exchange of communication, will be very enlightening as to whether actual physical possession had already been delivered to the buyer, Your Honor.
So ang teorya nga po ninyo, pinapaturan niyo iba't ibang stages at klase ng delivery. At kung hindi pa delivered, hindi pa kailangan ideklara. O sa kabilang banda, bagaman hindi rehistrado, kapag ka na-deliver na, hindi na rin kailangan ideklara. Yun po ba yung tamang pagkakaintindi?
No, what is determinative of whether a property should be entered into the sale of the filer, Your Honor, is whether you already have the ownership and possession of the property.
Ownership and possession.
That's correct, Your Honor.
When you say ownership, it means reflected in official documents or government records?
Correct.
For example, just describe us. In this case, your position is it was not yet accepted and therefore not fully delivered and therefore need not be declared. Even and also the name of the real property tax declaration is still in the name of the developer. Would that be correct?
That is what our evidence show, Your Honor. Because there was no actual physical delivery which allows the buyer to take possession of the property and exercise acts of ownership not until and unless the property had been delivered to him. And the non-delivery, Your Honor, if caused by factors which is also admitted by the seller, then that exempts the buyer from making an entry with respect thereto in his sale, Your Honor.
But on the reverse, Justice Cuevas, insofar as the Marikina property is concerned, if I'm not mistaken, there was delivery, but ownership was not yet fully vested, in fact, up to today, in the person of Mr. Vicente. Because I was thinking that your theory was delivery would consummate it.
What we were trying, there is no parity of issues, Your Honor. In the case of the Marikina properties, what we proved by our evidence is there was a sale. Now, whether there is transfer of ownership, whether there was a torrent certificate of title issued in favor of the buyer is immaterial as between the parties, Your Honor, because it is never a condition precedent to the validity of the sale that certificate of title had been issued in favor of the buyer. More so, if the buyer is not interested in the issuance thereof, Your Honor.
Mr. President, I will not engage in an argument with Justice Cuevas or counsel for defense, only that it is my wish that the legal theories and positions of the two sides, although of course they should suit their respective clients and clientele, I hope would be consistent insofar as all the items in the SALN is concerned, that we can catch the thread of the arguments.
With the kind permissions of...
Please, Your Honor.
There is no parity of facts between this Vicente case, Your Honor, and this case. The Vicente case deals with an existing property. In this particular instance, Your Honor, the contract to sale covers a property that still have to be constructed, Your Honor. It was not in existence. So practically it was a sale of a right, Your Honor. Now, when the building was constructed, it was only in 2006, Your Honor. So it is our humble submission that notwithstanding the payment of the price for the property purchased way back earlier than 2006, there could be no transfer of possession, Your Honor, because no property actually exists. In the Vicente case, Your Honor, the property was existing. And there is no necessity for the registration thereof by the buyer if he doesn't care to be issued the torrent certificate of title. The torrent certificate of title, Your Honor, binds the property against the entire world.
If I may interject with the permission of the gentleman.
Yes, Mr. President.
Sorsogon, the theory of the defense, there was no asset to be reported.
I'm sorry, Your Honor, I didn't get with your pardon, Your Honor.
In other words, the theory of the defense is there is no res or thing to be delivered and accepted. There was no asset to be reported.
We have not gone that far, Your Honor. We were merely trying to solve the issue of whether he is already the owner, so much so that he is under obligation to report it in his SLN.
All right. Go ahead.
I submit, Mr. President. Thank you, Justice Cuevas.
Thank you also.
Are you through with the marking? Where is the next witness? Miss